Welcome, everyone. So glad you could join us today. I'm Tora Johnson, and I head Venables Healthcare Group. Our presentation today is the National Nursing Home Initiative in a COVID-19 World. I'm thrilled to be joined today by my fellow Venable colleagues, Celia Van Lenten and Jerry Sachs, as well as Susan Betancourt from Health Concepts and Patrick Pilch from BDO. I'll let them each introduce themselves, but before we do that, just a few reminders. It's been a while that we're in our new normal, but we are still in our new normal. So if you hear any dogs, kids, or spouses in the background, just forgive us. And we'd love it to be as interactive as possible. So there's a Q&A feature at the bottom of the screen. So please feel free to submit your questions as they come to mind. And with that, Celia, would you like to introduce yourself?
Thanks, Tora. Good afternoon, everyone. My name is Celia Van Lenten, and I'm counsel in Venables Healthcare Group. I represent long-term care facilities and other types of healthcare providers, as well as insurance companies and health IT companies on a range of healthcare regulatory and transactional matters for long-term care facilities. Specifically, I advise my clients on matters involving Medicare participation and compliance, state licensure, government audits, HIPAA, and risk management, and I also assist those in this industry with transactional matters.
Thanks. Jerry?
Hi, everyone. I'm Jerry Sachs. I am a partner in Venables Government Division. My practice focuses on government investigations, helping individuals and corporations who are unfortunately being investigated by state or federal government agencies, both in the civil and criminal sense. In my former life as a federal prosecutor, I did bring and settle a number of False Claims Act cases, which is generally relevant for the healthcare industry. And I look forward to speaking to everyone and with my panelists today.
That's great. And Susan?
Hi, good afternoon, everybody. My name is Susan Betancourt. I'm a registered nurse, and I'm the Chief Compliance Officer for Health Concepts. We are a management company in Providence, Rhode Island, and we manage 11 skilled nursing facilities in the state.
That's great. And to round off our panel today, Patrick?
Yes, thank you, Thora. And hello, everyone. This is Patrick Pilch. I am Senior Managing Director and National Healthcare Leader with BDO. We focus advising our clients in this space across a number of what we call significant drivers, including movement towards consumerism, regaining trust to patients, reimbursement by clinical outcomes, and looking at those concepts in the context of making sure that there's strong compliance, and in the event there's investigation, we advise with counsel our clients through this process. And it's great to be here and looking forward to this conversation with you all.
Yeah, it's really fun to have such a diverse group of panelists on our program today. So let's get started and look at the agenda. We'll start with some background on the Department of Justice's Nursing Home Enforcement Initiative, and we'll look at some of the enforcement tools they have at their discretion. And then I do think it's really important that we look at the interplay with COVID-19. CMS released data in June that indicates that 1 in 10 COVID cases is related to nursing homes, as is 1 in 4 COVID deaths. So we will spend a little bit of time about the interplay between the initiative and what we are all experiencing today. Then we'll look at some measures that you can take today to avoid inquiry, and then what to do if, despite your very best efforts, the DOJ does pay you a visit. And with that, Jerry, do you want to tell us about how we got here today?
Sure, that sounds great. So the National Nursing Home Initiative was started by the Department of Justice, or announced, I should say, by the Department of Justice on March 3rd, 2020. It was likely developed pre-COVID and way before it was announced. If anyone has ever worked in or with the Department of Justice, you know it moves kind of like an aircraft carrier, very slowly. But it carries with it significant legal firepower, for lack of a better way to put it. The initiative is one that seeks to coordinate and enhance the civil and criminal efforts to pursue nursing homes, not that are making minor violations or regulatory compliance errors necessarily, but that are providing grossly substandard care to their residents. One of the stated announcements about this initiative is to not just hold the corporate entity responsible, but also the individual owners that have profited from that. Unclear as to whether that would go from just an individual person who owns a company or seek to hold, for example, substantial investors responsible as well. But it would be unwise to assume that the Department of Justice would not avail itself of all opportunities to hold people responsible for substandard care. Currently, the DOJ has said that they are focused on the worst nursing homes around the country. And just quoting some statements from the Attorney General himself relating to what that means, and we'll talk a little bit more in detail about that as the presentation goes along. But generally, the Department of Justice is looking to pursue the most deplorable in the industry, those that put the health or safety of residents at risk, where seniors are being mistreated, undernourished, neglected, and effectively where residents are literally being eaten away by bed bugs or scabies or have bed sores and are not being provided with the prescribed medication or left screaming in pain or unattended to. So essentially, DOJ, the initiative is to focus on really facilities that are unfit for living and plagued by, in the Attorney General's words, filth, mold, insects, and rodents. Just to put that into perspective. This initiative builds off of the DOJ's Elder Justice Initiative that is a coordination among different federal government agencies from HHS, the DOJ, to U.S. attorneys' offices, to state attorneys general offices as well. And building off of that, the current National Nursing Home Initiative looks to support its enforcement efforts by coordinating with local and state prosecutorial authorities and likely elder justice professionals, such as elder justice advocates or other types of advocates that have issues or substandard facilities on their radar. The Department of Justice rarely announces new initiatives without announcing that some investigations are underway. What I think is a little bit surprising is sort of the high number here, where there's approximately 30 nursing facilities in 9 states that, as of the time of this announcement, were already under investigation by the Department of Justice. I would suspect that that number has increased since the announcement of the initiative. More states, more local or other authorities probably wanted to join in. We also obviously have the pandemic, which has highlighted issues at nursing homes. And while this initiative is not a pandemic initiative, that, as we'll talk about later, does have some interplay into how the Department of Justice will pursue nursing homes as part of this initiative. Here are just some examples. Again, a little bit less graphic than what I just read as a statement from the Attorney General, but DOJ will look at nursing facilities that fail to provide adequate care, don't have basic protocols of hygiene or infection control, that don't provide residents with enough food or pain medication, or use physical or other restraints when not indicated because it makes their job easier, for lack of a better way to put it. And so that is the gist of where this initiative came from. Again, probably something in the works for some time, but it seems to be a well-coordinated initiative with on varying levels within the federal government and within the state and local governments as well. And with that, let me turn it over to Celia.
Great, thanks, Jerry. As my fellow panelists and the listeners today know all too well, the nursing home industry is subject to an really overwhelming number of regulatory regimes that are overseen by a bevy of federal and state regulators. And the list shown on the slide here is frankly a drop in the bucket with respect to the enormity of the regulatory oversight of this industry. But it does represent some of the more significant enforcement authorities that nursing homes contend with. On the federal side, many of the laws at play are aimed at preventing fraud, waste, and abuse against government health care programs like Medicare and Medicaid. And the False Claims Act in particular is arguably the most aggressive enforcement tool that could be used due to the significant civil and criminal penalties that can come from a violation. And Patrick will be delving deeper into that later in the presentation. The anti-kickback statute, the healthcare fraud statute, and the mail and wire fraud statutes are also used as enforcement tools, sometimes on their own, but oftentimes combined with the False Claims Act to prosecute fraud, waste, and abuse. And most states also have their own versions of these fraud and abuse laws. Nursing homes that participate in Medicare and Medicaid also have to comply with the Nursing Home Reform Act and the Medicare and Medicaid conditions of participation for long-term care facilities, which dictate the services that nursing homes must provide and other requirements that are associated with the day-to-day operations of a nursing home. I'm frankly sure that the Department of Justice is already mining CMS data from nursing home surveys to identify nursing homes that may meet the criteria for their nursing home initiative. On the state side, nursing homes are also subject to many other requirements that dictate their operations that come from state licensing authorities. And before the DOJ nursing home initiative was announced, it really was the state regulators that drove surveys and enforcement actions where there were concerns about substandard care through the state surveyors that carry out CMS's compliance oversight, along with the state licensing requirements oversight. These state regulators have historically had closer relationships with the nursing homes that are under their purview than federal regulators, in large part due to the regular surveys that they conduct and the work related to responding to complaints and managing corrective action plans and the like. And if there is a quality of care concern, it's those state regulators who can really quickly investigate on-site using that survey authority. It's not that the Department of Justice has never used the False Claims Act to prosecute nursing homes for quality of care issues before. It really has been used a number of times, including a notable case that resulted in a settlement last year with a nursing home chain that agreed to pay an $18 million settlement to settle a False Claims Act action for grossly substandard care. And the actions of substandard care in that particular case hit many of the examples that Jerry talked about as being cited in the announcement of the DOJ nursing home initiative back in March, like failure to administer medications, provide infection control, attend to basic nutrition and hygiene, take measures to prevent bed sores, physical restraints, and the like. However, the Department of Justice has had issues recently in certain federal circuits with some of its False Claims Act cases dealing with substandard care. And in light of the Department of Justice enforcement priorities in both healthcare and elder fraud, the department is likely looking to use the initiative to crystallize the path for using the False Claims Act more often to prosecute nursing homes that provide substandard care to residents. And with that, I will turn it over to Patrick to discuss the False Claims Act in more detail.
Great. Thank you, Celia. So the False Claims Act has been around for well over 100 years. It started actually in the 1860s during the Civil War. And the purpose of it is really to make sure that the federal government is not being defrauded. And in this case, in context of healthcare, a false claim is a payment, a claim for payment of services that either were not provided specifically as they were presented, or there's a payment that was received that the provider was not entitled to receive payment for. Key is that the person or provider in this case must knowingly submit a false or fraudulent claim to the government or make a false statement with respect to getting such claim approved. And that provider knowingly conceals or avoids an obligation to pay money to the government that's liable for both damages and penalties. Now, the key thing is that there's not a need to prove, no need for proof of specific intent to fraud, but the provider must have demonstrated knowledge. So that's important in terms of your compliance program. deliberate ignorance, or reckless disregard through the process in terms of submitting a claim. Now, the penalties can be significant. It ranges between 11,000 or so, just about 11,000 or so, to 23,000 for each false claim. The treble amounts for the government damages, and there's also possible criminal charges. And then even more importantly, on top of that, you may be excluded as a provider, from providing services under federal health care programs such as Medicare and Medicaid. There's additional possible charges under the anti-kickback provisions, healthcare fraud statutes, mail and wire fraud, which all add to those components in context of the false claim. So, what are examples of potential false claims related to substandard care? Well, certainly for services you didn't provide, but you submit a claim for that. For claims for worthless services, meaning services that are not of value in terms of the overall clinical care of the patient, that adds value to that clinical care. Upcoding or claims for higher higher level of service than actually was provided, and also claims for that were not medically necessary to provide. We come across a lot in our expert work that we provide that service. And then lastly, it's looking at services that are provided and submitted for service provided by individuals who are not licensed in your facility. That's very important. Now, there's another layer of this on top of that, which is something to consider, is the overpayment. There's a 60-day rule in self-disclosure in terms of the overpayment. We can discuss that later in today's webinar, but that's also another consideration you need to look at, meaning if you received a payment or overpayment of services, it also falls into that category in terms of remitting it back to the government, but you have to do it within the 60 days. Otherwise, you risk the ire of the federal government. And with that, I'll turn it back to Celia.
Thanks so much, Patrick. As Jerry mentioned earlier, failing to adhere to basic protocols of infection control was one of the factors that the Department of Justice cited in its announcement of the Nursing Home Initiative back in March. And while everyone is talking about infection control in nursing homes now because of COVID, infection control is not a new issue in this industry. Nursing homes that participate in Medicare or Medicaid have long been required to maintain an infection prevention and control program, and many state licensing laws also require similar infection control programs. A report issued by the U.S. Government Accountability Office in May of this year reported that CMS data shows that infection prevention and control deficiencies were the most common type of deficiency cited in surveyed nursing homes, with 82% of all surveyed nursing homes having at least one infection control-related deficiency between 2013 and 2017. And the deficiencies can range from situations where nursing home staff did not use proper hand hygiene, failed to isolate sick residents, or failed to use masks or other PPE to control the spread of infection. However, COVID really has brought the nursing home industry to its knees when it comes to infection control in a way that is really unprecedented. Nursing homes are inundated with guidance from the CDC, CMS, and state public health officials regarding infection prevention and control of COVID. And I'm sure, as Susan can attest, that guidance is changing all the time. It's just really a lot to keep up with. On top of that, the measures that are needed to adequately prevent and control an infection that spreads as easily as COVID are resource intensive. You're talking about screening, testing, PPE, rearranging the physical setup of the facility to allow for COVID units and isolation, not to mention needing to provide care for residents who are sick. And all of this is happening with the backdrop of staff shortages due to exposure concerns and the need to quarantine, test, sick leave, and related staffing issues. Back in April, CMS required nursing homes to inform residents and their families of COVID cases in their facilities and to report their COVID cases and deaths to the CDC. And CMS started making this data publicly available on its website last month, along with data from targeted inspections of facilities that were done pretty early in the COVID outbreak. In terms of investigative activity, CMS paused non-emergency surveys pretty early on in the pandemic to help prevent the spread of the disease on the one hand, and then to allow the surveyors to zero in on the more serious issues that were going on. CMS did recently, I should say that CMS did continue some of its surveys even when that suspension happened early on, particularly when dealing with immediate jeopardy complaints and fraud and neglect allegations, and relevant to this, complaints about infection control. As of now, most of those routine survey activities have started to resume and frankly have new fire lit under them with the CARES Act. The CARES Act actually provided an additional $80 million in funding to CMS and state surveyors to ramp up their survey activities even more. And for states that receive this CARES Act funding, they will have to perform on-site surveys of nursing homes that previously had COVID outbreaks, and they will also have to perform on-site surveys of any nursing home that reports a new confirmed or suspected case within 3 to 5 days of that report. Last month, CMS announced that it was also increasing its own enforcement of facilities with persistent infection control violations by using higher civil money penalties and also imposing enforcement actions against lower-level infection control deficiencies to make sure that they are addressed before they get out of hand. And one of the more notable enforcement actions to date by CMS was against a facility in Washington that had at least 37 COVID-related deaths. That facility was fined $611,000, and its participation in the Medicare and Medicaid programs is currently at risk unless they're able to demonstrate that their deficiencies have been corrected by September. Outside of CMS, the Department of Justice has announced investigations into a number of nursing homes related to COVID that really fits within that DOJ National Nursing Home Initiative mold, including one in Massachusetts where at least 76 residents died from the COVID outbreak. The OIG is also prioritizing COVID-related investigations as part of its work plan, which it recently updated mid-year, which it really includes two COVID-related components, one that focuses on auditing nursing homes' infection control programs, and another that will look at CMS's oversight efforts during the pandemic. And state governors, state attorneys general, and other state authorities across the country have initiated similar investigations into nursing homes related to COVID. Again, a lot of it focused on infection control. And for those investigations, we're seeing particular activity in New York, New Jersey, Pennsylvania, Massachusetts, and California. And it's worth noting that the investigations in Pennsylvania and New Jersey do include a criminal component to them. With all of this doom and gloom, it can be said that an ounce of prevention is worth a pound of cure. So with that, I will turn it over to Susan to discuss what nursing homes can be doing now to prevent a government investigation.
Thank you, Celia. And of course, compliance during a pandemic, there's no user's manual or playbook for this. So being a compliance officer is no easy task, but if you add on this national pandemic requiring physical distancing and being quarantined, it's an unimaginable burden, but here we are. So compliance from a distance is the new normal, and during these unprecedented times, you got to step back and ask yourself, what can I do to help the facility? Addressing any new guidance, regulations, and waivers that have been implemented in your facility in response to the pandemic is a great start. Many facilities have no time to review documentation and ensure that policies are being followed appropriately. So ideas on assisting facilities could include increased reviews of clinical documentation to observe for any trends or missing links, or perhaps looking for ways to case manage resident care to minimize unnecessary exposure to residents and employees. Some of the examples of care management assistance could be reviewing upcoming laboratory orders to ensure that the least amount of lab drawers are ordered to minimize the exposure from lab technicians coming into your facility that could infect your residents and staff. You can assist facilities with documenting communication to resident representatives. As Celia said, that is a huge focus, and making sure that we have that documented is imperative. Or you can help with the use of telehealth to conduct physician visits and use it for performing therapy evaluations and or treatments. All of that is extremely helpful to a facility who is in the middle of a crisis. Compliance does not go away, so your focus needs to adjust slightly and think of new strategies to help the facility during the crisis. When speaking of compliance, nobody is first in line to receive the training. So you have to think about how you can increase compliance awareness seamlessly without affecting employees' time, but still get their attention. Some ways is you can create or update a flyer that you use to advertise your hotline and ask the facility to post this new version in highly visible areas. The flyer is a great way to communicate visually to your employees that you are available and ready to hear their concerns. This type of advertisement also works well for your providers and families. So it's great to send this communication when you do send out communication to family members on your weekly reports. That's a great way, and especially when the visitor restrictions are lifted, they'll see these advertisements in your facility. This is a very difficult time for your employees, and giving them an opportunity to voice their concerns in the long run will help them as well as your facility. Risk management is the key, and overall compliance should be on your mind at all times. Policy and procedure updates are vital to a dynamic compliance program, and having a good archiving system is very helpful for risk management. Any new releases or updated guidance from CMS, the CDC, and your state health department should be your focus to ensure that your policies and procedures reflect the changes and recommendations that have been accepted and implemented in your facility. Having a software system to facilitate your policy updates is a great way for your employees to stay current and have access to policies at your fingertips at any time. This is very helpful when training time is limited. As a nurse, we were taught that if it wasn't documented, then it didn't happen. Well, although that is true, your documentation needs to tell the story for it to really support your efforts. It is also important to be sure to document what didn't happen. This will help avoid any gaps in documentation, which can be interpreted incorrectly as an omission of information. As Celia noted in a previous slide, the regulation on infection control was certainly an easier statement to say before we entered into this nursing home initiative and this pandemic. After reading the infection control regulation, you should ask yourself the following questions. How did your facility get to where you are today? If an allegation for poor infection control practices was presented to you, what would you need that could help you defend such an allegation? You need to document your facility actions and every step of your work plan. Having documentation that tells the story on how your facility prepared and weathered the pandemic storm could help protect you from any future liability. While no one is perfect and there is no magic answer, having evidence to support what your facility did and how it reacted is far better than no documentation at all. No one person has the answer to this virus battle, but rest assured, in the upcoming months to a year, we will hear questions like, why didn't you do this? Or why didn't you do that? Because everyone will be a Monday morning quarterback. So document, document, document. If you take anything from this webinar today, I hope it's document, document, document. The release of waivers in response to the pandemic will certainly spark a wave of auditing and monitoring from all angles of the post-acute care industry. Now is the time to gather resources used to develop and implement your facility plan and perform risk assessments regularly to identify areas of weakness. Create an electronic file and save a copy of any and all waivers, guidance, notices on regulatory changes, articles, newsletters, memos, whatever you have, as it relates to the national pandemic and how your facility reacted to the guidance. Ensure there is adequate documentation to support the use of waivers in your facility. If your facility has a meeting or gathering to discuss any changes or implementation plans, take notes. After several meetings, you will be surprised at how much information you have gathered and the timeline that you're creating to support your facility's efforts. Thinking about protecting the notes as intellectual property as you would with QAPI documents. Marking them confidential sometimes is just not enough. Your legal counsel may offer guidance on how to obtain and preserve this type of intellectual information. Jerry will now tell you what to do if there's a knock on your door.
So what to do if DOJ comes knocking? There's no set procedure, but these are some recommendations that will help anyone who is served with a DOJ subpoena or a search warrant or masked federal agents at their door. I say that a little tongue-in-cheek because I think everyone is masked nowadays coming to any nursing home facility, or hopefully should be. So what to do if DOJ comes knocking? The first thing I tell all of my clients is take a deep breath, let's figure out what's going on, and let's have a well-reasoned and planned out response. For lack of a better way to put it, freaking out initially is okay, but you have to take that deep breath, and then you have to figure out whether what you've received is a criminal investigation, a civil investigation, investigational demand. You have to look and see whether the subpoena, let's just take a subpoena, for example, if it's asking for information about the nursing home itself or about a patient or about some other facility or some other information outside of your own activity. So the first step is taking a deep breath, looking at what you've been served with. The next step should be finding competent legal counsel who can help you through an investigation. And I mentioned that not just because I'm an attorney speaking to everyone here on a webinar, but because if you represent yourself, you put yourself in a difficult position in which anything you say can be used against you. I know that sounds like a Law and Order sort of TV plug, and I can hear the music in my head. But truly, anything you say to the Department of Justice can come back to hurt you. And if a lawyer says something, on the other hand, there is always room for clarification and room for amending or updating. Obviously, you try to get it as correct as possible in the first go-around and build credibility, which is extraordinarily important. And again, counsel can do that for you by meeting with the Department of Justice and saying, look, I've been through this before. Here's what we're doing to gather information. Documents and data have been collected and preserved, or we're in that process, and here's what's going on. Absolutely under no circumstances should any type of shredding or deleting or removing of material be undertaken. That may look and sound great in a movie. I have rarely seen that be successful. When I used to prosecute computer intrusion cases, some of the best hackers in the world made one minor mistake that the FBI caught in a matter of seconds and led to all of their extradition from far off countries back to the United States, or to the United States, I should say. So again, you want to gather up the documents. Ideally, because you've listened to our webinar, it will be the documents that Susan has just spoken about, which detail, and everyone has spoken about, which detail your compliance with protocol, with policies and procedure, with providing non-substandard care, or whatever it is that they are investigating at. With counsel, consider whether immediate action at the facility is necessary or beneficial. And I say consider that. I've had clients before fire employees, and that is not something that I recommend without thorough consideration. When you fire an employee, they tend to turn against the business. They would turn against the nursing home. They might be predisposed to be neutral, and now you've just sort of poisoned that well by firing them. The other thing to think about with managing employees, and I'm not saying that firing or terminating an employee is not necessary or should not occur, because there are situations where that will absolutely be necessary. But separations can be handled in a variety of ways, including an agreement to provide competent counsel for that person who has been let go. And the example I will use is, in some cases, the companies I've worked with have agreed to provide counsel for an employee who has decided to amicably separate from the company, whether it's to pursue a new opportunity or because they just don't want to work at the company anymore. And what that does is it allows your counsel to help that former employee find competent counsel that can work with the company. Of course, that counsel will represent the individual's interests, but they may, if you have a relationship with them, may be willing to work more closely with you. The next step is to start your own investigation with your attorneys so that it's covered under privilege, and to try to ascertain what the Department of Justice is investigating. Is it one complaint from one family or one consumer advocate related to one specific issue, or is it something that is more systemic? And so those are things that you want to consider, whether you can get to the bottom of what the Department of Justice is looking at before they do, for a number of reasons. One, to stop any ongoing activity that may be unlawful, to remediate any harm, to put a plan in place or policies and procedures to prevent it from going forward in the future, and then to leverage that in discussions with the Department of Justice. And the last few steps are really just make sure that if you're served with a civil investigative demand or a grand jury subpoena, that that you understand your contractual obligations. If you have investors in your nursing home, you may have a contractual obligation to notify them that you've received the formal process from a government agency. You don't want to not comply with something that is as simple as forwarding an attachment to an email. And generally speaking, even though it is the Department of Justice and it's an adversarial proceeding and they're looking to bring a criminal case, you want to pick your battles because you're looking to come out the best in whatever war you have now entered into with the Department of Justice. And you want to cooperate when possible. You want to disagree respectfully. You want to choose which points you're going to relent on. When I was a prosecutor, civil and criminal, a lot of times people would come in overly aggressive at the beginning, and I can tell you that never benefited their clients. Most government attorneys are career attorneys. They will be there for the long run. They aren't getting overly compensated for the amount of hours they're working, and what they have to stand on is their reputation and their legal work. And so coming out aggressive, either attacking the prosecutors or the policies or the process usually is not the best route to take. I tend to recommend cooperating with the Department of Justice when possible, and when not possible, fighting the substantive battles, not the sort of ticky-tacky little issues that don't have outcome determinative impacts on what's going on. And I think that's where your focus should be. And I did, mention, masked agents showing up at your door, and that is something that cannot be ruled out, because if the Department of Justice does want to make a showing of force in combating substandard care, they could execute search warrants on the property with federal agents and start taking everything. Again, if that occurs, you may want to take a deeper breath, but you still don't want to do anything impulsive. You don't want to run down there and scream at the agents or obstruct justice or get in their way. You want to plan how to respond accordingly and then manage the situation as best you can. And so those are some of the main steps as to how to handle the Department of Justice and what to think about should you find yourselves in the unfortunate circumstances of receiving, being on the receiving end of the Department of Justice as a target of an investigation, or a subject, as they call it, for that matter. And I say subject as they call it because, again, if you're a witness or they're just getting information from you, that's not sort of as dire straits as if you're the target and the Department of Justice is looking to put someone in jail. Generally speaking, the last few points I'll make are, when the Department of Justice comes knocking, you know, for corporations, they are generally looking at some type of monetary compensation or payment because you cannot put a corporation in jail. Now, Attorney General Barr was pretty specific in announcing this initiative that they are going to look to hold individuals responsible. There obviously are different standards of proof required for a civil, to hold someone responsible civilly versus criminally. So time will tell as to how that pans out as far as holding individuals liable. But I point all of this out because I think dealing with federal prosecutorial authorities is different than dealing with state regulators or working within a highly regulated industry where you really don't have a choice but to cooperate with your regulators. And so when it comes to sort of the open books policy or open doors policy, or very little pushback when it comes to state or other regulators that supervise nursing homes, that is not necessarily the same with the Department of Justice, and that's just something that should be considered. And you know, this is me reading the crystal ball, but here's my guess that you will see a number of investigations open throughout Florida just because of its higher elder population. The U.S. Attorney, the head of all federal prosecutions in the Northern District of Florida, has already announced that he is actively participating in this initiative. And I would expect nothing less from the Middle District and the Southern District of Florida, if not to be left out, but just because they have significant populations of older Americans. And so with that, let me turn it back over to Thora and see if we have any questions. I think we have potentially a few.
I have one for you, actually, Jerry. And maybe maybe others can chime in. But there are a lot of states that have passed legislation providing immunity to nursing facilities and other healthcare providers from the COVID-19 lawsuits. What impact, if any, does that immunity have on DOJ enforcement efforts?
Great question. So state immunity does not necessarily provide immunity to the Department of Justice prosecutions. I say not necessarily because you'd want to look at sort of the underlying facts, and obviously, you know, I don't want to give a theoretical, concrete answer on a webinar, but generally speaking, you know, you can still be in compliance with all state obligations, and the Department of Justice can find something wrong at the federal level. Likewise, the state can say, we're not prosecuting anyone during, let's just say, the pandemic, or we're going to say if you take a COVID patient into your facility, you know, we, the state, are not coming after you. We need people to help do this. The federal government still could. And so that sort of dovetails back into all the compliance mantras that we've heard throughout the webinar, which are, even though the state is going to give you immunity, if you're going to do something, make sure you're documenting exactly what you're doing. Make sure that you're documenting, hey, we are accepting COVID patients because the state has given us immunity. Nonetheless, we are taking the following 15 protocols to ensure that they are quarantined or isolated or separate from the remainder of the nursing home, that only certain staff is going there with extra PPE, personal protective equipment, and things of that nature. And so you want to lay out policies and procedures that would comply with federal standard, notwithstanding your immunity from the state standard. One other thing, you know, let me just jump back to one other point, which was, you know, I mentioned don't fire your employees. You know, something else that's important when considering that is, you know, your employee trying to leave or an employee you might not like might be a whistleblower. And so, if you're on knowledge of the whistleblower, you have to comply with a whole set of differing regulations and not take any retaliatory action. But also, if the whistleblower is still your employee, you may have more access to their information. One other example that I can give is a former or an employee who leaves and becomes a former employee takes with them, all of their personal items and happens to have the only copy of one key document that really drives your point home to show the regulators that you weren't doing something wrong. To the extent that person is not a former employee or they've left with some sort of cooperation, understanding, or the like, you would have an opportunity to go track that down and get it back quicker than getting into a legal fight with that person saying that that's truly your property, for example. And I don't know if others want to, as regards to how to handle or manage whistleblowers. I'm sure we've all dealt with them.
This is Celia. I actually wanted to just jump back to the conversation about immunity for a moment. I just want to discuss a different angle of immunity because we have seen a number of states that have granted nursing homes immunity from lawsuits, private lawsuits related to their good faith provision of care to their residents during the pandemic. Some of that's come through executive orders, others that have come through state legislation, and states have really varied as to what that immunity looks like. Some of them are granting immunity, or I should say not granting immunity in cases involving willful misconduct or gross negligence, which is a higher bar than what plaintiffs' lawyers usually have to show. And some states have just shielded facilities from civil liability. Others have granted immunity for both civil and criminal liability. However, this particular grant of immunity applies to lawsuits that would come potentially from residents, their families, and other private plaintiffs who are impacted by a COVID outbreak at a nursing home. They would not impact the federal or state investigative and enforcement actions that we talked about today, coming from Department of Justice, CMS, OIG, state attorneys general, and others. And I imagine that some would argue that the increased investigative and enforcement efforts from regulators are really necessary to account for the fact that nursing homes cannot be held liable in court against private litigants for civil or also potentially criminal claims. I have caught wind, though, that there are plaintiffs' attorneys who are not necessarily deterred by the immunity in the states that have them. They are perhaps taking on some of the more egregious cases just to account for that higher burden of proof. Others may be using equal protection causes of action rather than torts to make a case. And then still others are apparently seeking to challenge the constitutionality of the immunity. It seems like the immunity that comes through the executive orders from governors may not stand up as well as those that have come through the legislature. But that's just to put a cap on the immunity conversation.
That's great. Thank you.
So I'm thinking about this. This is Patrick. I think that one of the things that I look at, because we've done a lot of self-disclosure work with in cases where there's an overpayment, inappropriate overpayment. Most of the time it comes after a merger, an integration of some sort, and there's the determination by a compliance officer. So that self-disclosure process is, it's often, it depends on where you are, right? So it depends on if you're the acquirer. I mean, is there a difference in that window, in that discovery for due diligence, or is it the law applies the same to all? So whether you're the acquired or the acquirer, is it the same?
So the law should apply to everyone equally. You may have different sort of standards as it comes to, if we're talking about, say, criminal intent or otherwise.
Yeah.
There may be some differences there if you've, let's say, acquired a bad practice from another facility. You still, depending on how things were set up in the transaction, and otherwise you may still be on the hook, civilly. You may still be on the hook criminally, depending on how long it's occurred and what's been done. So, but if it's a practice that was discovered after a facility being acquired, obviously you want to look at how you can remediate that as quick as possible and protect yourselves from either civil or criminal liability. But in terms of the law, it should cover all participants in the industry.
So that leads me to my next question, because the data that we all see coming from CMS, everyone sees. So let's say if you're a provider, Jerry, Celia, or Thora, you're a provider, Susan, so if you're a provider acquiring another facility, and the facility has, has a reputation of, poor clinical outcomes, maybe low star rating, things of that nature. In that process, would it not make sense to have a due diligence focus on the potential for some issues that we're discussing today? In terms of the potential false claims, potential inappropriate, medically unnecessary treatment, et cetera. In that due diligence process, would that hold to be prudent at that point, or do you wait until you fully integrate the organization? It's not like to me, it's not sometimes an obvious question, because you may not find that out in the due diligence process. This makes a difference in how you set it up. And frankly, what if you find that out in the due diligence process and determine you don't want to acquire that organization, right? Are you required to disclose that?
I'm happy to take that one. I mean, I would argue that you would want to do really deep enough due diligence to find that out on the front end, because the liability is just so significant on the back end that if it's a stock deal, you're buying the liability, and so you want to leave no stone unturned in that process. And there are certainly, while asking the question like, were you committing fraud, is unlikely to garner really helpful responses. There are a lot of different, more specific questions that you can ask in that due diligence process to help ferret out potential fraudulent behavior. So I would certainly advocate for finding that out on the front end, because it could very much be a deal breaker. And I've absolutely seen quality issues be a deal breaker in long-term care transactions before. As it relates to, a self-disclosure, if you haven't bought the liability, it's not your liability to disclose. So I would say in that case, you walk away from the deal if that's how things go, and you're done. I've also seen, however, the buyer require the seller to do a self-disclosure pre-close and handle indemnities and limitations of liability that are specific to that self-disclosure, separate from the rest of the deal, to try to insulate the liability with the seller. The government may not necessarily look at it that way if they're investigating it post-closing, but at least between the buyer and the seller, they can allocate at least financial liability between the two of them in whatever's been negotiated in the purchase agreement.
That's great. I'm aware of the fact that we're coming up against our hour, and I thought we could close with okay, I'm being prompted to remind everybody their CLE code, and that is National 2020. But I thought that we could conclude with each of our panelists giving final thoughts on the topic. And if anybody wants to jump in first, go ahead and take the wheel, or I will call on you.
So this is Jerry.
I'm happy.
I'll jump. Oh, Go ahead. Well, here, this is Jerry. I'll go ahead and jump in first. Sounds like that was Celia. So I will turn it over to you. My closing comments are, an ounce of prevention is worth multiple pounds when it comes to defensive investigation. So I'm probably going to steal some of Susan's lines here, but document, 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 and then if an investigation comes, be prepared and work your way through it calmly and collectively. And now over to you, Celia.
Thanks, Jerry. I would say that, I mean, given the dynamic that we're in with COVID, while the initiative didn't start as a COVID initiative, it's absolutely ripe for use right now. It's already being used, but the environment that we're operating in from a regulatory perspective is changing almost hourly, and it's really imperative for facilities to stay on top of that, which can be a really overwhelming exercise if you do it alone. So I would just encourage nursing facilities to use your trade associations, use your consultants, use your legal counsel to help, to help keep you abreast of what is most relevant for you. If it requires a modification to an existing policy, if it requires a new policy, if you need to do a new training, whatever it might be, don't go at this alone because it can be overwhelming at times.
And this is Susan. I can speak from being in the provider community. I don't think there's anything that needs to happen right away, unless you have somebody that's not breathing. But I would always say just stop and take a time out. Even if someone's knocking at your door, you have FBI looking at you in the face, there's nothing imperative that needs to happen right away. You have to step back, take a time out, pull in your resources, call for help, and discuss it before you react. I think a quick reaction can really hurt you significantly. So taking that time out, like the referees do, it's imperative. And I think that'll help in all aspects of what you do in your daily, day-to-day operations.
Yes, so this is Patrick. I would just finish up a couple things. First, hire very good counsel. That's important. And also consider, if you were to acquire your own facility, what would you look at from the risk perspective? And if you can do that process. And that could help with self-disclosure ultimately, but also it helps you with having good, strong compliance in place to help you and be prepared for any event that the DOJ or other regulatory bodies start knocking at your door.
That's great. And I just want to give my hearty thanks to everyone who has joined us in the audience today and to my co-panelists. And I wish everyone to be well and healthy, and hope everyone has a good remainder of the day. Thank you for joining us today.
Thank you.